Uh, Good morning, everyone. So we will have our less supplemental discussion for lesson 9, prosecution introduction. So prosecution na tayo. Tapos na tayo sa prime mover of justice or also known as the police pillar. Nang proceed naman tayo kung ano ang function ni prosecution sa criminal justice system natin. For begin, just recap lang. Meron tayong limang pillars ng justice system, the police, na siya yung search, research, of course, other sa offender, and of course, we have the prosecution, the court, correction, and last but not the least, the community. So we have the learning objectives here to identify the causes that can or cannot be covered by amicable settlement, recognize the importance of process of an amicable settlement. Sorry, iba yung ko natin. To discuss the prosecution pillar pala yan. Iba yung nilagay natin doon. Sa ibang topic pala. Okay, prosecution. Kung nakakita na kayo ng prosecutor, sobrang connected siya dito sa topic natin. And of course, kung nakakita na rin kayo ng fiscal, sobrang connected rin siya. Kasi fiscal, yung prosecutor, isa lang yan. Noong unang ng mga unang kwan pa araw, ang tawag natin sa prosecutor ng fiscal. Accordingly, sa mga nababasa natin, because of, siyempre, yung hindi naman lahat. Yung iba lang na may kawain na corruption, fix. Kaya yung fiscal, ginawa nilang fiscal yung fiscal kasi they fix. Kaya pinalitan na lang nila, talawag na lang nila ng prosecutor. So yun, prosecution. In this stage of the criminal justice system, first, determination of the legality of the action of law enforcement. Yung prosecution, excuse me, it will determine the legality of action of the law enforcement. Ibig sabihin nun, they will evaluate if there is something violated by the law enforcement officer in conducting their search or in conducting their arrest, in conducting arrest of the offender. For example, ito, pag yung tao na-arrest nila through warrant of arrest, ang gagawin dyan is de-determine yung legality by conducting preliminary investigation para malaman kung meron bang probable cause yung kaso at kung para malaman din kung may na-violate na constitutional right yung mga police officer. And of course, kung by virtue of warrantless arrest naman, kung na-arrest yung tao kahit wala kang arrest, but it is falling under the valid warrantless arrest. Ang ikakandak naman nila is inquest proceeding. Okay? Okay, evaluation of the evidence presented takes place. Okay? Ang gagawin pa ng prosecution ay i-evaluate yung mga pieces of evidence presented. Paano? Yung mga police officer, i-represent nila sa prosecution yung mga ebidensya laban sa offender. Ngayon, evaluate pa kung relevant ba yung mga ebidensya na yun, kaya pwede ba siya or admissible ba siya na gamitin sa korte? So, no. Yun. And of course, presence of probable cause to warrant prosecution, known as preliminary investigation, will be determined. So, yan yung sinabi kanina. Okay, three main functions. We have the three main functions of prosecution pillar. To conduct preliminary investigation, to conduct inquest proceeding, and to act as a lawyer of the state in criminal prosecution. So those are three functions of prosecution pillar: to conduct preliminary investigation, to conduct inquest proceeding, and to act as a lawyer of the state in criminal prosecution. Yun po. So we have the Department of Justice. Si Department of Justice o si DOJ, the DOJ obtains its function from Executive Number 292. Okay, is an Administrative Code of 1987. So please take note of that for board examination purposes. Yung function niya nanggaling sa Executive Order 292. And of course, yung mandate naman ng DOJ is to uphold the rule of law and ensure the effective and efficient administrative of justice. So yun po yung mandate ng DOJ. It is the principal law agency and legal counsel of the government. So, DOJ yan ha. Siya yung pinaka-principal law agency and legal counsel of the government. Kaya nga meron tayong tinatawag na DOJ Secretary, Chief Justice. Okay? It is headed by the Secretary of Justice, assisted by three undersecretaries. Yung three undersecretaries na yun, sila si Assistant Secretary, Chief State Prosecutor, pero ngayon, Prosecutor General na, and the Chief State Counsel, the Bureau of Corrections, and the Board of Pardons and Parole, and support services, namely the technical staff, financial and management services, administrative service and management service office. So, yan, nanggaling tong article na to sa DOJ.gov.ph. So, for board purpose exam, yes, for board examination purposes, kailangan isaulo nyo yan. Maging familiar kayo dyan para sa kasi halos lumabas lahat yung mga basic information na yan. Okay, we have the National Prosecution Service or the NPS. So, as he is the Secretary of Justice in the performance of powers and functions of the department relative to its role as the prosecution arm of the government, particularly investigation and prosecution of all criminal cases except those under the exclusive jurisdiction of the Office of the Ombudsman. So, si National Prosecution Service or NPS, ito yung pinaka-head, ito yung ng ng ito yung pinaka-agency ng mga prosecution. Sila naman yung, ito naman NPS, ito yung nag-a-assist sa Secretary of Justice and DOJ. Except those under exclusive jurisdiction of the Ombudsman, yung Sandigan Bayan. So, officially, the NPS was constituted on April 11, 1978. So, please take note of that. With the issuance of PD 1275 by President Ferdinand Marcos. So, pag sinabi natin PD or Presidential Decree, automatically si Marcos ang may gawa niyan. Or yung mga iba pang mga president nun. The NPS consists of the Office of the Chief State Prosecutor, and the Office of the Regional State Prosecutor, the Provincial and the City Prosecutors. It likewise abolished the position title of Fiscal, the Prosecutor, to reflect more accurately the position's basic function. So, yan. Itong NPS, siya rin yung nagkuha ng abolish sa position na Fiscal. So, nga yung sabi natin nun, Fiscal. Diba? Okay. In the passage of RA 10071, an act strengthening and rationalizing the National Prosecution Service. The act changes the title of Chief State Prosecutor into Prosecutor General. Ito yung sabi ko kanina, hindi na Chief State Prosecutor, kundi Prosecutor General na ang tawag natin sa head ng NPS. Prosecutor General is assisted by 5 senior deputy prosecutors. So, formerly, Ang tawag sa kanila, Assistant Chief State Prosecutor. Pero ngayon, Deputy State Prosecutor. And a host of Senior Assistant State Prosecutors, Assistant State Prosecutors, and Prosecution Attorneys. So, yun po yung Vice Assistant ni Prosecutor General. Excuse me. Pagagaling na natin sa trangkaso eh. So, the NPS is under the supervision and control of the DOJ. NPS is considered as the prosecutorial arm of the government. Okay? Siya yung prosecutorial arm of the government. So, kung may mga kaso si gobyerno na kaharapin, ang magiging prosecutor niya si NPS. Siya mag-defend sa kanya. Okay, let's proceed naman kung anong trabaho ni public prosecutor. Si public prosecutor, it is demanded of him nothing less than utmost diligence. Pag sinabi nating diligent, marunong siya kahit hindi siya utusan, kumbaga thoughtful siya. Ginagawa niya ng tama yung mga bagay na pinapagawa sa kanya, being the instruction. Okay? Unquestionable honesty, unblemished integrity. Ibig sabihin yan, yung unquestionable honesty, talaga honest siya. Isa siyang qualification as a public prosecutor. And of course, unblemished integrity. Wala siyang ni isang kinaharap na kaso na sisira or kung wala mong kaso, wala siyang example ng unblemished integrity is example. Kung yun, may anak ka sa labas, ibig sabihin nun, may blemish na yung integridad mo. Siyempre, ikaw ay kinasal sa isa, saka nagawa mong magkaanak sa iba. Ibig sabihin, may bahid yung integridad mo. And of course, in other traits pa na pwedeng mag-consist ng blemish integrity. And quiet dedication to serve the people at all times. So yung tahimik lang siya nagtatrabaho para i-serve ang mga tao. This is according to Attorney Claro A. Arellano, the Prosecutor General of the Philippines. But they also serve as the trial or prosecution officers before the criminal court. Ang ibig sabihin ng ito, the public prosecutor do not only initiate criminal action, ibig sabihin nun, yung pag-initiate ng criminal action, pag-file ng kaso, pag-file ng information. So, okay, para may makasuhan and then matry ang case niya and mapatulan ng guilty. Hindi lang yun, kundi ang gagawin pa nila, they also serve as the trial or prosecution officer before the criminal court. Sila yung lalaban para makulong talaga yung isang offender. Now, moreover, the prosecutors decide whether or not to prosecute a case or hold the case open for further action. Ibig sabihin, the prosecutor decide whether or not to prosecute a case. Pag sinabi nila, if they will prosecute, ibig sabihin, they are seeing a probable cause. Probable cause. O kaya, merong probable merong probable po nagsasabi dapat makasuhan yung isang tao and then magkaroon ng trial and present yung mga ebidensya laban sa kanya para makulong siya, para mahatulan siyang guilty. So yun pag may probable cause. Pero pag sinabi naman niya na to whether or not, to not prosecute a case, ibig sabihin, yung tinitignan pa lang nila yung isang kaso, wala nang sapat na ebidensya, ibig sabihin, they will not prosecute the case. Dismiss yun. Okay? Ganun po yun sa prosecution. So, before bago tayo pumunta sa private prosecutor, ganito kasi yan, pag si police officer may nahuli silang tao by virtue of arrest, dadamay yung taong yan dun sa prosecutor. Sir, ito, nahuli po namin. Ito po yung warrant niya. O kaya, ito, sir, nahuli po namin siya. Nagnakaw ng sasakyan, pero nahuli namin. Okay? The prosecutor will prosecute the case. Paano? Evaluate niya muna kung may sapat na ebidensya kung talaga nangyari yung krimen na alleged na pagnanakaw ng tao. And then, after that, titignan ng prosecutor kung tama ba yung kaso na isinampa ng mga police officer. Kung tama ba yung ginawa nilang pag-arrest. Kung may na-violate ba na guidelines o constitutional right. Na may medical ba yung tao o wala. Kung kumpleto lahat yun at saka matibay yung ebidensya, magpa-file siya ng information sa korte, kaya makakasuhan na siya din. Mangyayari doon, magkakaroon siya ng hearing ng kaso niya. Pag nakatulan siyang guilty, di kulong. Ganun yun. Ganun ang relasyon ni police officer sa prosecution. Magka-partner din yan. Kung may na-violate na guidelines or may kulang yung ebidensya, madidismiss yung kaso. So, babalik ulit yung mga police officer, maghanap ko yung ebidensya. Then, pagkatapos nun, pa-file ulit sila kay prosecutor. Ganun lang yun. So, proceed na tayo sa private prosecutor. Okay. Article 100 of the RPC, or the Revised Penal Code, meron tayo doon, civil liability of a person guilty of a felony. Kung criminally liable ka, civil liability is also connected. Big sabihin nun, may yung mga danyos na dapat mong bayaran. Civil liability, kung mag-commit ka ng felony or crime, violation of the Revised Penal Code, meron ka babayadan ng mga damages, yung fine, moral damages, yun. Every person criminally liable for a felony is also civilly liable. That's the rule. Because of this, the private complainant may acquire the service of private counsel. Okay? Yung private counsel yun, guys, it will act as the private prosecutor to protect his civil rights as a result of a felony. Okay? Ang gagawin ni private prosecutor, yung example, yung mga private complainant, kaya sila kumukuha ng private na attorney because it will serve as the private prosecutor to them para ma-secure yung civil liability, yung civil rights niya. Example, okay, isira yung mga paninda niya, yung complainant dahil dun sa suspect. Kailangan bayadan ng suspect yung mga yun kasi syempre kaya pinahiya ng suspect yung complainant. Moral damages yun. Kailangan bayadan yun. Yun ang ina-afteran ng prosecutor, private prosecutor, o ng niya. However, the private prosecutor is under the direct control and supervision of the public prosecutor. So, syempre, hindi pwedeng independent na gumalaw yun. Kailangan under the direct control and supervision of the public prosecutor. So, nag-uusap din si prosecutor, public, at si private. Excuse me. Okay, we have the ombudsman. Siya yung tinatawag na special prosecutor or tanod bayan. The ombudsman is created under Section 5, Article 6 of the 1987 Philippine Constitution. So, si Ombudsman, siya yung mag-handle sa graft and corruption cases. Plunder, ganun. Excuse me. So mandates RA 6770 of the Ombudsman Act of 1989, powers and function, fact-finding investigation, administrative adjudication, preliminary investigation, prosecution, public assistance, enhance efficient effectiveness, transparency, accountability, and responsiveness. Yan yung mandato nila. Okay. Dito tayo sa institution of criminal action. Sinabi natin institution of criminal action shall be instituted as follows. The filing of criminal charges. Ibig sabihin yan. For an offense where a preliminary investigation is required by filing the complaint, the proper officer to conduct the requisite preliminary investigation. Ngayon, yung mga offense kasi na kailangan ng preliminary investigation, yun yung mga may penalty na 4 years, 2 months, and 1 day. Kung pasok doon, yung penalty, kailangan ng preliminary investigation. Kung hindi, no need. Pero kung mag-request yung complainant, for all the offenses by filing the complaint or information directly with the MTC and the MCTC or the complainant with the Office of the Prosecutor. In Manila and other chartered cities, the complaints shall be filed with the Office of the Prosecutor unless otherwise provided in their charters. For all other offenses by filing the complaint or information directly with the MTC and MCTC sa Manila. Again, yung institution of criminal action, yan yung pag-file ng case. Okay? Effects of institution of criminal action. The institution of criminal action shall interrupt the running of period of prescription of the offense charged unless otherwise provided in special laws. Ang ibig sabihin ng prescription of the offense, yun yung example, ito, it will interrupt the running of period of prescription. For example, nakakulong, naka-detain yung naka-detain sa Orlando. Ngayon, sa Orlando, naka-detain siya. It is considered na nag-prescribe na rin yung nag-start na rin yung prescription ng offense niya. Ibig sabihin yung penalty ng offense na, yung alleged na offense na na-commit niya. For example, mayroon siya penalty na 6 years. Nag-start na doon. Pag nag-institute na ng criminal action or nag-file na ng case sa prosecution, ma-interrupt yung pagbilang nun. Ibig sabihin, mag-stop muna siya. Mag-pause. Okay? Unless otherwise provided in special law. May mga special law naman na this shall not interrupt the prescription of the offense. So, okay, tuloy pa rin. No, the complaint or information shall be in writing in the name of the people of the Philippines and against all persons who appear to be responsible for the offense involved. Okay, we have the complaint. A complaint is a sworn written statement charging a person with offense subscribed by the offended party, any peace officer, or other public officer charged with the enforcement of the law violated. So, sa complaint, written is our sworn written statement. For board examination purposes, lumalabas talaga to. It's complaint. So, familiarize nyo yung elements there. Sworn written statement charging a person with an offense subscribed by the offended party, any peace officer, police officer yan, other public officer charged with the enforcement of law violated. Teacher, pwede ba? No, hindi naman siya charge, hindi naman sila in charge sa pag-enforce ng law, di ba? PDEA, pwede ba? Pwede. Because they are enforcing drug act. So, kung regarding sa drugs yun, pwede. Offended party. Okay? Information naman tayo. So, sa information, is an accusation in writing charging a person with an offense, subscribed by the prosecutor and filed with the court. So, si information naman, yung pinagkaiba niya is si plain sworn written statement. Si information, accusation in writing, charging a person with an offense. Parehas lang. Kailang pinagkaiba sworn written statement. Ito naman, information, accusation in writing. So, ang gumagawa sa kanya, subscribed by prosecutor, si prosecutor. And it will be filed with the court. Si complaint naman, saan siya ma-file sa prosecution. Okay, ito yung table natin. So, si complaint, requirement must be under oath si complaint. Information naman did not be under oath kasi uh, ang under oath, yung mga police officer mag-o-oath siya sa prosecution. Kasi prosecution, meron na siyang prosecuting power para mag-charge ng case. So, no need na maging under oath. Excuse me. Who must prosecute criminal actions? All criminal actions either commenced by complaint or by information shall be prosecuted under the direction and control of the public prosecutor. Okay, all criminal actions either commenced by complaint or information shall be prosecuted under the direction and control of a public prosecutor. Please be familiarized with that. And second, in case of heavy work schedule of the public prosecutor or the event, or in the event of lack of public prosecutor, the private prosecutor may be authorized in writing by the prosecutor office or the regional state prosecutor to prosecute the case subject to the approval of the court. So, pwede yung private kung walang approval. Pero kung may approval, pwede. Authorized by the prosecutor of prosecution office or the regional state prosecutor. And then, subject to the approval of the court. Court who handles the case. Okay, once the court that has jurisdiction over the case. Once so authorized to prosecute the criminal action, the private prosecutor shall continue to prosecute the case up to the end of trial, even in the absence of the public prosecutor, unless the authority is revoked or otherwise withdrawn. Okay? That is effective May 1, 2002. Ito sa circular nila. Note, the written authorization to the private prosecutor shall be given because of either of the following reasons. The public prosecutor has heavy load or there is a lack of public prosecutor. So yan po yung reason kung bakit pwede yung mga pwede authorize yung private prosecutor na mag-conduct ng prosecution, na mag-prosecute ng cases. Prosecution of the private offense. The crimes of adultery. Okay. Meron tayong mga crimes against person, crimes against private yung mga private offenses or yes, yun. Crimes against person, against property, ganyan. Pero meron din naman mga tinatawag private offenses. Ito yung mga offenses na example, crimes of adultery, concubinage, shall not be prosecuted except upon the complaint filed by the offended spouse. Ang private person dyan is yung offended spouse. Siya lang yung pwedeng mag-prosecute. Ibig sabihin, mag-file ng case. Hindi pwedeng mag-file ng case yung kapamilya niya, o kaya yung ibang attorney, o kaya yung ibang police officer. Siya lang na naapektuhan. Pwede. The offender party cannot institute criminal action prosecution without including the guilty parties, if both are alive, nor, in any case, if the offended party has consented to the offense or pardoned the offenders. Ibig sabihin nun, yung offender The offender party cannot institute criminal action. Yung offender naman, hindi siya pwede institute ng criminal action kung wala yung guilty party, yung offended party. If both are alive, nor in any case, if the offended party has consented to the offense or pardon the offender. Ibig sabihin, uh, pinatawad na. The offenses of seduction naman, abduction, and acts of lasciviousness shall not be prosecuted except upon a complaint filed by the offended party of her parents, grandparents, or guardians, nor in any case if the offender has been expressly pardoned by any of them. If the offended party dies or becomes incapacitated before she can file the complaint, and she has no known parents, grandparents, or guardians, the state shall initiate criminal action in her behalf. So, yung ito, basa naman natin. Note, private offenses are those offenses that cannot be prosecuted without a complaint first filed by the offended person himself. Hindi pwedeng magkaroon ng prosecution ng private offenses kung wala yung complainant or yung offended party na magpapal ng complaint first. The prosecution of other crimes not mentioned above may be initiated by other persons since there are crimes against the state. Bigamy and rape are not considered private offenses. So kung may nakita kayong na-rape, pwede kayo yung mismo mag-file ng case dun sa offender. Hindi kailangan na meron yung consent ng offended party. Not unless pinardon niya rin yun. Pwede sila magpakasal, pinatawad na lang niya yung nang-rape sa kanya. So, pwede rin yan. May extinguish yung kaso. Yung penalty. Excuse me. Minor has a right to initiate the prosecution of an offense. Minor has the right to initiate the prosecution of an offense. So, kahit minor pala, meron siyang, excuse me, meron siyang right to initiate the prosecution of an offense. The offended party, even if a minor, has the right to initiate the prosecution of an offense, of the offenses of seduction, abduction, and acts of lasciviousness independently of her parents, grandparents, or guardian unless she is incompetent or incapable of doing so. So kung competent siya at meron na siyang discretion or meron siyang mabuting pag-iisip, in crimes of seduction, abduction, and acts of lasciviousness, he or she can independently uh, initiate the prosecution of an offense. Okay, so yun. And then, where the offended party, who is a minor, fails to file the complaint, her parents, grandparents, or guardians may file the same. The right to file the action granted to parents, grandparents, or guardians shall be exclusive of all other persons and shall be exercised successively in order herein provided, except as stated in the preceding paragraph. So that's the rule. Okay? And second, no criminal action for defamation, which consists in the imputation of any of the offenses mentioned above, shall be brought except at the instance of and upon a complaint filed by the offended party. So that's section 5 of Rule 110, Institution of Criminal Action. No criminal action for defamation, yung paninirang puri. Kailangan yung complainant pa rin. Effects, excuse me. Effect of RA 7610 or the Special Protection Against Child Abuse, Exploitation, and Discrimination Act. Under Section 27 of RA 7610, complaints on cases of unlawful acts mentioned in the law committed against children may be filed by the following. So, offended party, the parents, the guardians, ascendants, or collateral relative within the third degree of the consanguinity. Kung sinabi natin collateral, pag ganun siya, horizontal yung pa-horizontal yung relasyon. Basta hanggang sa third degree lang. Officer, social worker, or representative of licensed child care institution, officer or social worker of the DSWD, barangay chairman, or at least three concerned responsible citizens where the violation occurred. So, yun yung kwan. May be filed by the following. Ito. So, about sa child abuse, exploitation, and discrimination. And we have determination of sufficiency of complaint or information. A complaint or information is sufficient if it states the name of the accused, yung pangalan ng accused, Norman E. Ay Norman Makapagal Arroyo E. Estrada. Okay? The designation of the offense given by statute, ibig sabihin nun, people of the Philippines versus blah blah blah, Norman, or crime of murder. Kung wala naman, for example, special law yun, violation of Section 5, RA 9165 sa drugs. Ganun yun. The acts or omissions com complain as constituting the offense. So, yung mga acts or omission. So, nakalagay sa complaint din yung mga acts or omission. For example, ng acts, okay, by stabbing the victim 3 times. O yung omission naman, by not uh, giving an aid to the victim. That's omission. You omitted. Example, the name of the offended. Okay, kailangan nandun rin yun para masabi na sufficient yung complaint. Kompleto. Offended. Name of the offended party. Ay, magkatuloy ito ah. Dali lang. Yan. The approximate date of the commission of the offense. Kailangan nandun din yung approximate date at about 2 a.m. of Friday, January 5, 2023. Example lang. And at the place where the offense was committed in Kasikayan, Tabuk City, Kalinga. When an offense is committed by more than one person, all of them shall be included in the complaint or information. So, pag more than one, ilagay nyo lahat yung pangalan nila doon. Hindi pwede i-shortcut. As in, full name lahat. Hindi parang yung paggawa ng reference sa libro na apelyido lang. Dapat kompleto. Note, unless the date is an essential element in the commission of crime, the approximate date is sufficient in the complaint. Ano ba yung mga kailangan yung date, yung sufficient, essential sa element? Example, crimes of infanticide, di ba? Less than 72 hours dapat yung age ng pinatay para infanticide. Ano ba? Basta yung mga essential ang time. Duplicity of the offense is not allowed. Okay, a complaint or information must charge only one offense, exempt the law prescribes a single punishment for various offenses. So, yung isang complaint, kailangan isang offense lang ang nakalagay doon, hindi pwedeng dalawa. Okay, so that's all for our lesson 9 in tawag natin dito, criminal justice system. So, punta tayo dun sa ating tignan lang natin yung requirements nyo dun sa inyong lesson 9. So, yun. Present lang natin sandali. So, yun guys. Differentiate information from content. So, i-differentiate yan. Madali lang yan. Can a judge conduct a preliminary investigation? Yes or no? So, kailangan mo mag-search sa internet or sa criminal procedure. Rule, yung criminal procedure or rules of kailangan yung mga magbasa doon para ma-answer nyo to. So, the rest is multiple choice. Tulad ng dati lang yan. So, thank you guys for listening. Kung may katanungan kayo, meron tayong group chat.